Thank you for joining me on my YouTube channel. My name is Christiana Sage. On this channel, I will be teaching about international law, and these teachings will be in the form of short weekly lecture series. Over time, I will be surfacing varied concepts of international law. When and where applicable, these concepts will be analyzed and brought to you as it relates to current trends in international law as they arise. At the end of this lecture, you will find the transcript of the lecture in the link below. Also, for current trend and analysis in international law, you can subscribe to my blog. All the details you will find in the comment section below. We will be exploring the concept of state responsibility. Over the course of this series, we have addressed several concepts that become pertinent to understanding and fully grasping the notion of state responsibility. We have talked about the understanding of states in international law. We have situated states as subjects of international law and established that under international law, states relate with one another on the basic understanding that all states are equal and sovereign. As such, every state under international law has a right to sovereignty over its territory. So to fully digest the notion of state responsibility, we have to grasp fully statehood, which we addressed in Lesson 12, subjects of international law, which we addressed in Lesson 7, sovereignty and territorial integrity, which we addressed in Lesson 8. To situate the discussion for this lecture on state responsibility, we will be unpacking what state responsibility means under international law, what constitutes internationally wrongful acts, and what the consequences for internationally wrongful acts may be. What do we mean by responsibility and by extension state responsibility? So let's dive into the lesson of the day. When we think of responsibility, we think of words such as duty, accountability, blameworthiness, control, moral obligation, correct behavior, and so on. However you conceptualize the notion of responsibility, the underlying reality is that it demands a doing or an omission and donates a consequence for heeding or not heeding to the defined demands. How does this analogy become relevant for state responsibility, you might ask? To answer that question, I will be drawing reference to our previous lesson on subjects of international law in Lesson 7, where we had emphasized that states are the primary players or subjects of international law. So where there are players, there are rules, right? For example, in a soccer game, there are rules that the players must obey, and failure to adhere to these rules have consequences, such as either a player receives a yellow card or a red card when a foul has been committed. So therefore, at its basic level, state responsibility under international law accounts for the regime through which one state can make claims for reparation against another state for the commission of an internationally wrongful act or breaches of international obligations. Though not a binding document in the way that treaties are, Article 1 of the International Law Commission's articles on responsibility of states for internationally wrongful acts, which the United Nations General Assembly adopted in 2001, states that every internationally wrongful act of a state entails the international responsibility of that state. We have established that internationally wrongful acts necessitate state responsibility. But what then are internationally wrongful acts? And what does it mean to have state responsibility? Now we will look at that briefly next. Internationally wrongful acts. Engaging if there has been an internationally wrongful act, Article 2 of the ILC's articles may be a good place to start. This provision stipulates two elements of an internationally wrongful act, and they are acts that are, one, attributable to the state under international law, and constitute a breach of an international obligation of the state. So the next step to deconstruct this is then to ask, how do we reconcile acts that are attributable to states? And these answers we'll find in Chapter 2 of the ILC articles. Actions or omissions are attributable to states where they are attributable to, one, the organs of a state, conduct of persons or entities exercising element of governmental authority, conduct of organs placed at the disposal of a state by another state, conduct directed or controlled by states, and conduct of insurrectional or other movement that eventually became states. Going forward in our analysis, having established that the acts are attributable to the state, the next facet is to determine if the act or omission complained of constitutes a breach of an international obligation of the state. What amounts to state obligation is wide-reaching under international law. In one instance, it could include the destruction of state property. It could include violation of a nation's territorial integrity. Again, it could mean breach of a treaty, to mention a few examples. To situate this in a broader context, the International Court of Justice, the ICJ, offers rich jurisprudence on the range of breaches of international obligations that could prompt state responsibility. You may like to see the following cases. The case concerning the aerial incident of July 27, 1955, that's the case between Israel and Bulgaria. The Kofo Channel case, the case concerning the military and paramilitary activities in and against Nicaragua, that's Nicaragua versus the United States of America. I have gone ahead in the transcript to provide a hyperlink to each of these cases so that you can read and see how the ICJ reasoned it through and ascribed state responsibility. It does not stop there. When it has been deemed state responsibility, the next issue is to determine the corresponding consequence for a state found to have committed an internationally wrongful act. So to the consequences. We talked about the fact that in a game of soccer, a foul is against the rule of the game. And thus, when that happens, a player who commits a foul receives either a yellow or a red card. Oh, well, maybe not quite the analogy here, because unlike soccer, states are not per se sent away from the field of international law. However, there are ramifications when a state has been found to be committing or to have committed an internationally wrongful act. So the question is, what are they? That we will address briefly next. 1. Cessation. Cessation, as the name implies, indicates the non-continuation of a process. Thus, the state responsibility of cessation occurs when the act complained of is one of a continuing nature. In a situation where there is a continuing breach of international law or internationally wrongful acts being committed, the aggrieved state might either make a claim for cessation backed with assurances and guarantees of non-repetition, or, depending on the extent of the injury, make a claim for cessation and reparation. For example, in the Lagrand case between Germany and the United States of America, which concerned a violation of Article 36 of the Vienna Convention on Consular Relations, the court offers extensive extensive jurisprudence on the question of assurances and guarantees for future compliance with obligations under Article 36 of the Vienna Convention. The court offers extensive jurisprudence on the question of assurances and guarantees for the future compliance with obligations under Article 36, 1B of the Vienna Convention in this case. Next up, reparation. Article 34 of the Articles of the ILC particularizes how reparation may be offered in three ways: through restitution, compensation, and satisfaction, either singly or in combination. So let's unpack what these types of reparations entail. Article 3 of the Articles of the ILC speak to restitution as a form of reparation. Restitution signifies a restoration to the status quo. This is usually the most apparent method of reparation because it aims to reestablish the situation which existed before the commission of the Internationally Wrongful Act. Compensation is typically a monetary award for a wrong done or injury suffered. In the same vein, a state that has been injured by the commission of an internationally wrongful act of another state could be entitled to compensation. Article 36(1) of the ILC Articles encapsulates states' responsibility to give compensation where restitution is insufficient to make good the damage caused by the internationally wrongful act. In paragraph 151 of the 1997 case, the Hungary-Slovakia case, the judgment of the ICJ stated that it is well-established rule of international law that an injured state is entitled to obtain compensation from the state which has committed an internationally wrongful act for the damage caused by it. On the issue of satisfaction, Article 37 of the ILC's articles states that where restitution and compensation are insufficient, then there is an obligation on the erring state to make good through satisfaction. Satisfaction entails, according to Article 37 sub 2 of the ILC articles, acknowledgement of the breach, an expression of regrets, a formal apology, or another appropriate modality. To recap, we have gone over a general concept of state responsibility and analyzed the ILC's articles. Conceptualization of state responsibility. We have also given a few examples of the ICJ cases that touch on this issue. For a further and deeper understanding, you can explore some of these cases. The ICJ's jurisprudence provides an extensive offering in determining the range of how these consequences are attributed. So I want to thank you so very much for joining in, and remember to like, share, subscribe, leave your comments in the comment section below, and hit the bell icon so that you're notified when there's a new video. Also, engage with us on Facebook and Twitter, and let us know the content you'd like to see. Thank you.